Welcome to the Supreme Court of the United Kingdom. Today, the court is hearing an appeal in the case of the Secretary of State for Health and others, and Servier Laboratories Ltd and others. Details of the case can be found on the court's website by going to the Cases section and clicking on the link to Current Cases. We're hearing the appeal remotely because of the current restrictions on social contact. I'm hearing the appeal together with four of my colleagues. I'm the President of the Court, Lord Reid, and I'm hearing the case together with first Lord Lloyd Jones.
Good morning. Good morning.
Lord Briggs.
Good morning.
Lord Sales.
Good morning.
And Lord Hamble.
Good morning.
I'm going to invite now counsel for Servier, Ms. Bacon, Queen's Counsel, to begin her submissions. Ms. Bacon.
May it please the court. I appear with Mr. Pitchenin for Servier, which is the appellant here and the defendant in the main proceedings. For the respondents who are the claimants in the main proceedings, Mr. Turner, Queen's Counsel, appears for the English claimants with Mr. Drake and Mr. Wolfe. Mr. Beard, Queen's Counsel, appears for the Scottish and the Northern Ireland claimants. Ms. Laura Elizabeth John appears for the Welsh claimants. I will refer to the health authorities collectively as the claimants in my submissions today. The submissions on behalf of all of the claimants will be delivered by Mr. Turner. Following the President's order yesterday, Mr. Beard and Ms. John will relay any points they want to make through him. With the court's permission, I propose to structure my submissions as follows. I want to start with a few short introductory remarks. I will then take the court to the cases which we say are central to the EU concept of res judicata erga omnes. I will then address the claimant's key point, which is that the concept of res judicata erga omnes is only engaged where the subsequent proceedings concern the issue or subject that has already been settled by the EU court. And as I will show you, this proposition does not appear in any of the EU case law. I will then explain why we have said that the four propositions in dispute in our case are indeed res judicata. I will address the question of practical implications and boundaries quite shortly. And finally, I will respond to the claimant's submissions about the timing of any reference to the CJU should the court make one. So, starting with my introductory remarks, the issue in this hearing has arisen because, as you will have seen, of Servier's appeal to the European Court against the Commission decision that is also the foundation of the domestic proceedings. And as you will have seen, the General Court annulled the entirety of the Commission's finding that Servier had infringed Article 102 TFEU. And the Article 102 findings were annulled because the General Court found that the Commission got the market definition wrong. And the central reasons for finding the market definition to be wrong were that the court found that ACE inhibitors are therapeutically substitutable and are widely perceived to be substitutable by prescribers, both for new patients and for existing patients. And those findings were reached on the basis of extensive submissions and evidence on both sides. Servier's position is that if those findings remain following the appeal that is currently pending to the CJU, that should be an end to the matter. It should not have to re-argue precisely those points again in the domestic proceedings in a preliminary issue trial that the judge accepted would cost the parties together over £3 million. And the important initial points to note are these. Firstly, as you will have seen, the Commission's decision was based both on Article 101 and Article 102 TFEU. But the Article 102 findings were based on exactly the same conduct as the Article 101 findings. And that was the allegation that various agreements concluded between Servier and the other companies were anti-competitive. The only difference was that the Commission's Article 102 case included one further finding that was not in the Article 101 case, relating to the purchase of manufacturing technology from a third party. And for your Lordship's reference only, that point appears in the particulars of claim of the English claimants at paragraphs 45 E2F, which is at pages 260 to 261 of the electronic bundle. So, although the legal tests for Article 101 and Article 102 are of course different, in this case, what was and is in issue is one and the same set of events. The second initial point is that as matters currently stand, what is left following the General Court's judgment, and of course pending any different answer by the Court of Justice in the appeal, is a set of findings of infringement of Article 101, and it is precisely those findings that are pursued by the claimants as the foundation of these proceedings in what is left of this case. So as matters currently stand, the EU and the domestic cases are entirely aligned. The third initial point is that the findings of the General Court that Servier wishes to rely on go to exactly the same points that Servier has pleaded in its mitigation case, and which Servier will seek to rely on in the preliminary issue trial. And the best place to pick that up is in the Statement of Facts and Issues at paragraph 16, and that's in section 4 of the electronic bundle at page 58. Paragraph 16 summarises Servier's mitigation case, all the relevant parts of it, and then you can see at paragraph 30 of the Statement of Fact of Issues, which is at pages 62 to 63, the findings of the General Court on which Servier relies. So those are the places where you can see the comparison between Servier's arguments, which have been made since the mitigation case was pleaded in late 2016, and the General Court's findings. Now, you will have seen that the claimants say that there are various arguments that they will want to make in the preliminary issue trial that raise different issues to the findings of the General Court. And there's no dispute about this at all. The claimants can, of course, advance the arguments and evidence that they choose at trial, and they doubtless will argue that the General Court's findings are not determinative of the preliminary issues. But the relevant point for these purposes is that Servier does wish to rely on the General Court's 4 findings in that trial, which we say go to the central points in our pleaded mitigation case. It is also the case that the claimants, for their part, do not accept those findings as a matter of fact. And Mr. Justice Roth found in his initial judgment that various aspects of the claimant's evidence would indeed be precluded if the General Court's findings, the disputed 4 findings, are binding on the court. And the reference for that is paragraph 50 of the judgment of Mr. Justice Roth at pages 211 to 212 of the electronic bundle. So the propositions embodied in the 4 disputed findings of the General Court will be directly in issue at the preliminary issue trial, with Servier relying on those findings and the claimants disputing them. So in our submission, there is no question of uprooting or transplanting from one legal context to another, as suggested by the claimants. The legal context is one and the same, and Servier will be relying on at trial on precisely the same points that were considered by the General Court. So the question before the court today is whether the General Court's findings lose the force of res judicata in these proceedings, simply because those findings were made in the course of assessing whether there was an infringement, whereas the domestic proceedings are, as matters currently stand, concerned with the question of the quantification of damages. And as I will show you, there is nothing at all in the EU authorities suggesting that the principle of res judicata that we rely on is so limited. On the contrary, there is much to indicate that this case does fall within the scope and purpose of the doctrine of res judicata erga omnes. So I come then to what we say are the 5 main cases that sets out the principle and its boundaries. And these are in the authorities, which are in section 8 of the electronic bundle. And the first case is the P&O set of cases, which are at tabs 6 to 8 of the authorities bundle. And as you will have seen from both the Court of Appeal's judgment and our written case, these cases concerned support for a ferry company in the P&O group by buying tickets for a particular route from Portsmouth to Bilbao. And the judgments relate to 2 successive commission decisions. The first decision found that there was no aid, and that was challenged by a competitor to P&O, Brittany Ferries. And that gave rise to the BAI judgment, which appears at tab 6 in the authorities bundle. Now, you don't need to turn that up. All you need to know about that judgment is that the Commission's decision was annulled, essentially because the Commission had found that this was a normal commercial transaction and the court disagreed. And the relevant paragraphs of the court's judgment are paragraph 75 to 76 and paragraph 80, and those are at pages 1068 and 1069 of the electronic bundle. So those are the references for those parts of the judgment. The replacement decision of the Commission then found that there was aid, and that was challenged by both P&O and the aid granting local authority. And the important point to note is that the local authority was not a party to the first case. So the challenge then went to the Court of First Instance, and that is at tab 7 of the authorities bundle. And it's worth going to because the Court of First Instance, as it then was, decided the case in essentially the same way that the claimants would have you decide this case, on the basis that res judicata didn't apply where the subject matter of the second action was different. So the Court of First Instance's judgment is at tab 7, starts at page 1071. And as you will probably have seen, the res judicata point arose because one of the arguments of the local authority, which, as I've said, wasn't a party to the first case, was that on the facts, it maintained that the agreement was still a normal commercial transaction. And for your lordship's note, that's recorded at paragraphs 84 and 99 of this judgment. And the Commission objected that this particular argument was inadmissible on the basis of res judicata. And the court addressed that argument at paragraph 77 to 80 on page 1091 of the electronic bundle, and it rejected the argument of res judicata. And it said at paragraph 77 that it's well established that the force of res judicata can constitute a bar to the admissibility of the action if the action which gave rise to the judgment in question was between the same parties, had the same subject matter, and was founded on the same grounds. And then paragraph 77, res judicata cannot be pleaded where the actions in question do not relate to the same measure, since the measure whose annulment is sought is an essential element of the subject matter of an action, and so on. So the Court of First Instance found that res judicata was not engaged because it pointed out that the subject matter was different. The 2 cases related to completely different decisions, successive decisions taken by the Commission, and indeed the parties were also not the same. When the case went on appeal to the Court of Justice, the Commission didn't itself appeal on the res judicata point, but the court raised it of its own motion. And it was discussed by both the court and the Advocate General. Now that's the main case, which is at tab 8 of the authorities bundle. And that starts at page 1112 of the electronic bundle with the Advocate General. So the Advocate General discussed the point in his opinion And he reached the same conclusion as the Court of First Instance. And his reasoning starts at paragraph 67, and it's worth turning that up if you can go to it. That's at page 1125 of the authorities bundle.
Ms. Bacon, before we go to the reasoning, can I just raise a point with you? Just in relation to the facts of the case. The findings made by the General Court were based on a survey carried out by the Commission of Prescribers. And they surveyed prescribers across several member states. And they found that 51% of those who responded considered that there was an equivalent medicinal product to the one produced by Servier. Now, Servier had argued, in fact, that there was a selection bias in relation to the practitioners who were surveyed in France and the UK, but they were included nonetheless. Now, in our domestic proceedings, there's going to be an issue about whether there was reasonable behavior on the part of people prescribing or health authorities in, for example, Northern Ireland, and separately an issue in relation to Scotland, and the same issue in relation to Wales, and the same issue in relation to England. Am I right in thinking that on your approach, there's no possibility of for even trying to break down the survey results? You simply have to take the finding made by the General Court across the EU on the basis of the various states surveyed and treat that as the state of the relevant fact in relation, for example, to Northern Ireland.
So, my lord, there are several answers to that. So first of all, the General Court's findings were made on the basis of a large amount of evidence, and it wasn't just that survey. That survey was, of course, one of the pieces of evidence. There was a huge amount of evidence, including expert reports, that were submitted to the General Court. So that was one of the pieces of evidence. In response to your question, well, having reached those findings on the basis of all of that evidence, do the General Court's conclusions stand? Do the General Court's conclusions stand, even if there is other evidence adduced?
I'm not questioning the General Court's conclusions. They were looking at the issue at an EU level.
Yes.
And what I'm wondering is whether it's possible to go behind that conclusion, for example, by analysing the evidence on which it was based, insofar as you can relate it to particular member states or parts of a member state for the purposes of the domestic proceedings.
Well, you're essentially suggesting that one would look at an even more granular basis for the General Court's findings. We have sought, as the case law indicates, to extract from the General Court's judgment the main findings that are ratio. Now, the point that I was going to make was that, of course, in the preliminary issue trial, it will be open to the claimants to make other arguments about whether the General Court's findings are determinative of the issue before the court in the preliminary issue trial. And the claimants have said that they're going to do that. The claimants have said that if you look at other factors, the question of reasonableness is not determined by the findings made by the General Court. So it will be open to the claimants to make those arguments, and we have never disputed that. What we say cannot be reopened is the general finding that is made by the General Court regarding substitutability, because that was made in relation to market definition in the relation to the Commission decision, which the claimants are relying on. And the claimants are relying on the Commission decision to establish their case. It's a case about 101 and 102.
So the answer, I think, is that that findings made by the General Court, either about actual substitutability or about perceptions of substitutability, cannot be gone behind.
Yes, that's the point, and that's the effect of the res judicata argument. The claimant's case is brought on the basis of Article 101 and 102. The General Court's findings were made in that context, and according to the case law, those there stand as res judicata. But as I've said,
So for example, if 100% of British doctors regarded Servier's product as not being, as not having any satisfactory alternative, that wouldn't matter if it wouldn't make any difference. If the survey results showed that a majority of doctors across the EU considered that it was substitutable, and on that footing the General Court made a finding that it was substitutable, that's that.
That's as far as substitutability goes, and as far as the evidence of therapeutic substitutability goes. But as I've just said, it is of course open to the claimants to say that other factors specific, and this is what they are going to say, other factors specific to those claimants and those PCTs in whatever region of the country meant that it was reasonable of them to prescribe perindopril, Servier's product, rather than other products. They will say that, and it's open to them to say that in the domestic preliminary issue trial. What is not open to them is to go behind the point of substitute. This is our case. It's not open to them to go behind the point that is settled by the General Court. And it will then be for us to make the submissions that we want to make about relevance of that in the trial. And the point is not that they're precluded from making their argument. The point is whether we can make our argument by reference to the General Court.
You're not relying only on a finding as to actual substitutability, but also as to perceptions of substitutability.
Yes.
Would it be open to the health authorities to establish that whatever view the General Court might have reached on the basis of a survey across a number of member states, the facts in, say, Northern Ireland were that most doctors regarded perindopril as not being substitutable satisfactorily?
Yes, and they will be able to rely on specific evidence, and they are, as I understand it, proposing to make submissions on the conditions in individual PCTs not necessarily being the same across the country. And that's
the case. Can I ask what the relevance is of the General Court's finding about the state of medical opinion across the EU as a whole?
Well, the General Court's finding will apply to the general view, and Servier will wish to argue that the General Court has found that the products were substitutable as a matter of fact. And so it can't be disputed that the products were, objectively speaking, substitutable, and across the EU were perceived to be substitutable. And then we propose to build our case on that. And the relevance, it really has been settled at first instance by the trial judge. He's found, as I've said, that the points that we want to make in our mitigation case are valid points to make. We are entitled to make them, and indeed some of the claimant's evidence will be precluded by those points. So he's looked at the evidence and he's established that the points are relevant ones. That, as I understand it, is not disputed. The claimants, of course, say we've got lots of other arguments that we're going to make, and we don't dispute that.
Thank you very much. You've clarified that for me, and I'm afraid I had interrupted you when you were taking us to P&O ferries. Just one more point. I'm being asked to mention that there was, of course, as part of the evidence before the General Court, specific evidence from, for example, primary care trusts in Scotland and Northern Ireland. So, so there was specific evidence from different parts of the UK. So I was just about to take you to the conclusions of Advocate General Tizzano in the P&O Ferries case in the Court of Justice, and I had just said that he reached the same conclusion as the Court of First Instance, and his reasoning starts at paragraph 67 on page 1125 of the authority of the electronic bundle, and the starting point that that he mentioned at paragraph 69 was that although the local authority who raised the point that was said to be res judicata hadn't been a party to the first case, he wasn't convinced that that in itself was decisive. What he thought was decisive was the question of whether the two cases had the same subject matter, and he addressed that at paragraph 71 and following. And his starting point was that the decisions in dispute didn't have to be identical as such, because the issue about identity was more about the identity of the points of law before the court. But a crucial point of difference in this case, he thought, was that the second decision was based on a new factual appraisal, including new evidence submitted to the Commission. And you can see that at paragraph 75 to 77 of his opinion. He gives some examples of the new evidence at footnote 40. And in his view, the fact that there was new evidence meant that res judicata didn't bind the courts to follow the original judgment. So that was what the Advocate General thought. And then if you then scroll on to look at what the CJU said, it disagreed. And the relevant part of the CJU judgment starts at paragraph 40, which appears at page 1167 of the electronic bundle. And it's at the bottom of page 1167. And the court took a completely different approach to both the CFI and the Advocate General. Its starting point was that the criteria of the same subject matter, same parties, same grounds didn't apply. So the relevant test was not whether the second action arose in the same legal context, concerned the same subject matter, or whether the parties were the same. You can see that at paragraph 41. Rather, the annulling judgment had the force of res judicata with absolute effect. And what that meant, as the court explained at paragraph 41, was that legal questions that had already been settled could not be reopened. And as the court repeated at paragraph 43, an annulling judgment has authority erga omnes, giving it the force of res judicata with absolute effect. And importantly, the court then also clarified that the authority of res judicata in such a case attaches not only to the operative part, this is paragraph 44 of the judgment, not only to the operative part, but also the ratio decidendi of the judgment that is inseparable from the operative part. So two propositions, res judicata erga omnes, so it applies to everyone, and secondly, that authority attaches also to the ratio of the judgment. And the court then went to set on, and that's on the next page at paragraph 46, various points that it considered were the basis of the annulling judgment, including the conclusion that the agreement was not a normal transaction, and then another point about the interpretation of what was in Article 92, subparagraph 1, the state aid rules. So paragraph 46. Can I interrupt you for a moment? in paragraph 44, when they say that that authority is also attached to the ratio decidendi of that judgment, which is inseparable from it, and see to that effect asterisk paragraph 27. When you go to asterisk, it is rather more limited in the way it's put there.
Well, I was going to go to asterisk next.
Right,
so
fine.
I'll take you to that, and I'll explain what was happening in asterisk. So I just wanted to finish with P&O, and then we'll then go back to asterisk, because you're absolutely right, my lord. You need to then look at asterisk to find out what is meant by ratio decidendi. So having set out those 2 points of principle, the court then applies those.
May I just intervene before we leave P&O in the CJEU? I note at paragraph 47, the court said no appeal was lodged and its operative part in the ratio therefore became final.
Yes.
Is the finality of the decision a condition for its res judicata erga omnes effect?
Yes, that's absolutely right, which is why Mr. Justice Roth rightly said that if he found that in principle res judicata did apply in this case, such that the general court's findings were in principle binding, we would then have to wait to see whether those were overturned by the Court of Justice. And that's common ground. And I'll come on at the end of my submissions to the timing of a reference on that.
Thank you.
My lord, you're absolutely right. Had there not been an appeal, the position would have been as in P&O, that the general court's findings were final at that point. So I was just showing you paragraph 46. So 46 is where the court essentially extracts what is ratio, or at least what is ratio for the purposes of the issues before it. And then it then explains at paragraph 50 that it followed from that the particular argument that was advanced by the local authority couldn't be re-examined without disregarding those findings, which were res judicata. So this judgment is expressly rejecting the approach of the Court of First Instance and the Advocate General of asking whether the subject matter and grounds and so on of the two cases were the same. Instead, the court puts the analysis the other way round and says you first have to ask what is the matter that's been determined in the operative part and the ratio of the annulling judgment. So that's what the court did at paragraph 56, extracting the ratio. And you then ask whether the plea that is advanced in the later proceedings would require the re-examination of something that fell within the scope of res judicata. And that's paragraph 50, the specific argument put forward by the local authority. And of course, there were other arguments, but that specific argument conflicted with the res judicata of the earlier judgment. And that's precisely the approach that we submit applies in this case. By contrast, the claimant's approach of starting by asking whether there is a sufficient identity of the subject matter for the res judicata principle to be engaged is precisely the approach that the court was rejecting in this case. I can then turn to asterisk because asterisk it's necessary to read this judgment together with asterisk because it incorporates by reference paragraph 27 of asterisk, as the court has already noted. So asterisk is at tab 3 of the authorities bundle. It was decided about 10 years before P&O, and it was a case about EU aid for tomatoes. And what happened there was that the calculation of the aid payments was set out in a new regulation every year. And the original judgment, which isn't in the bundle, the original judgment turned on a point about Greek packages being smaller than the norm. And that meant that certain coefficients that were used in the regulation for the year 1983 to 1984 discriminated against Greek producers. And in the original judgment, the 1983-1984 regulation was therefore annulled to the extent that those coefficients resulted in an inequality of treatment to the detriment of the Greek producers. Following the judgment, the Commission acknowledged rightly that it had to correct the position for the 1983-1984 year. The way it did that was by adopting a new regulation which gave the Greek producers, and only the Greek producers, additional aid for that year, so it levelled them up. But the Commission refused to grant the levelling up aid, the additional aid, for any other years, because it said, and again it was right to say so, the annulling judgment had only concerned the 1984 year, and that was correct. The annulling judgment did only relate to that year. But the Commission's refusal to take account of the annulling judgment for the other years was then appealed, and that's this case. That's this case that you have before you, which the court cited in P&O. And the key passage, as my Lord Reid has noted, is paragraph 27. And you can see paragraph 27 on page 976 of the electronic bundle. And that says that in order to comply with the judgment and to implement it fully, the institution is required to have regard not only to the operative part of the judgment, but also to the grounds which led to the judgment and constitute its essential basis insofar as they are necessary to determine the exact meaning of what's stated in the operative part. It's those grounds which on the one hand identify the precise provision held to be illegal, and on the other indicate the specific reasons which underlie the findings of illegality contained in the operative part, which the institution concerned must take into account when replacing the annulled measure, because this of course was the case about the Commission taking the judgment into account. My Lord, in answer to your question, we don't seek, nor did we seek before the Court of Appeal, to place any gloss on paragraph 27. We adopt the definition of ratio in that paragraph, the grounds which led to the judgment and constitute its essential basis insofar as they are necessary to determine the exact meaning of what's stated in the operative part. That's the definition that we adopt. And what the court was therefore making clear in this paragraph was that the point that was decided in the original annulling judgment, which gave rise to obligations on the Commission to implement, was not merely confined to the operative part, which of course the operative part was confined to the 1983-1984 year. The court was making clear that actually the obligation on the Commission extended to the grounds that constituted the essential basis of the judgment. So the Commission couldn't simply look at the operative part or even the subject matter of the annulling judgment, which was the 1983-1984 regulation, but it also had to comply with the grounds that were essential basis. That's why the court had to make that point in asterisk, and that's the point that's incorporated by reference in P&O. So the direct consequence of this for the asterisk case, you can see in paragraph 31 at the bottom of the same page, was that the Commission was bound by the judgment on the coefficient point, not only in relation to the 1983-1984 aid, which had been the subject of the original annulling judgment, but it was also bound by what the court had said about inequality in relation to the aid to be paid for later years, even though the later aid was not put in issue in the annulling judgment. And in fact, what is noticeable is at paragraph 24, which is on the page before paragraph 27, it's at page 975, the court explicitly says that the aid situation for the later years was a different situation to the one governed by the annulled regulation. And you see that in the middle of the paragraph. Those regulations thus relate to situations different from those governed by the annulled regulation, because it concerned aid payable in later years. So the effect of this case was to confirm that the ratio of an annulling judgment can have a binding effect that goes beyond the subject matter of the annulling judgment, in the court's words, that applies to situations different from those governed by the annulled regulation. And this point about the annulling judgment applying to beyond the subject matter of the issue before the court in the original case is also made in some of the sequels to P&O, which I would like then to turn to in chronological order. And the first of the sequels to P&O chronologically is the Perez-Diaz case, which is at tab 19 of the authorities bundle. And that judgment in its official form is only in French. So we've provided an unofficial English translation, which starts at page 1536 of the electronic bundle. The facts of this case are set out at paragraphs 53 to 55 of our written case. And essentially, the Commission had conducted a recruitment exercise in which it had rejected not only Mr. Perez-Diaz, but also 2 other candidates. Unfortunately, we referred to those in our written cases as being male. They were in fact both women, the 2 other candidates, Ms. Sabag and Ms. Bachete. And all 3 of the rejected candidates sought separately the annulment of their rejection decisions. And all 3 annulments were successful, but the other 2 candidates, the 2 female candidates, obtained the annulment of their decision on an important ground that Mr. Perez-Diaz had not himself advanced about the changing constitution of the recruitment panel. And when the decision then went, following the annulments, back to the Commission, Mr. Perez-Diaz said that he was entitled to rely on the point made in the other 2 annulling judgments. And the Commission rejected that submission. And that was the subject of this judgment, where the General Court found that the relevant point in the other 2 judgments was res judicata and bound the Commission in relation to its decision for Mr. Perez-Diaz, who hadn't raised the point. And if we can pick up at paragraph 50, which is on page 1543, that sets out the principle, and while not citing asterisk, it echoes the formulation in asterisk. I've tried to look at the case that it cites, but unfortunately the full judgment in the Frederickson case isn't available on the court's website. So I'm no further enlightened as to why that Frederickson case was cited. But in any event, the formulation in paragraph 50 is very similar to the asterisk formulation. Then paragraph 52 identifies the relevant point in the grounds or reasoning of the 2 other judgments. And that was that the committee had not been able to ensure the, should we say, equality of treatment of the tested candidates because of the instability of its constitution. Paragraph 54 is the next important paragraph. Now, that is not translated very well, but the essential point that is being made here is that even if the operative part of the other 2 judgments was confined to annulling the decisions in those individual cases, the reasons for the judgment were generally applicable to other candidates. And those are the words generally irregular in the last 2 lines. In the 4th line of the translation of paragraph 54, not for the surplus, I think that should say something like not for the remaining candidates or not for the other candidates. So what it's saying is that the annulling judgments in Bachete and Sabag were of course confined to the case before the courts in those cases, not any other cases, but the reasons were generally applicable, as is said in the second part of that paragraph. And then scrolling down to paragraph 60, this said that the Commission's position disregarded the res judicata of the grounds that were the necessary support for the operative parts of the Sabag and Bachete judgments, i.e. the point about the changing constitution of the Commission. That was one of the grounds that was the necessary support for those judgments. So that's the point where the court applies a point in the judgment of Bachete and Sabag to Mr. Perez-Diaz. The claimants say that this isn't a borrowing case, but is simply a case of the Commission having to implement its new procedure in a way that corrected the flaw identified. But that really misses the point in our submission, which is that in its new decision for Mr. Perez-Diaz, the Commission was notably bound by a finding in the other two cases, which was not in the annulling judgment that the Commission was implementing for Mr. Perez-Diaz. So the subject of the Perez-Diaz case was his rejection decision. So that was materially different from the issue in the other annulling judgments, which concerned the rejection of other candidates. But the point made in the grounds of the findings in the other two cases was the court held res judicata and applicable to him, and therefore had to be applied to him. So this is another example of a specific finding in the grounds of an annulling judgment being applied to a different decision, and in that case involving a different person. That's the first of the P&O sequels. The second P&O sequel that I wanted to take you to.
Just before we leave this one, thus far, but correct me if I'm wrong, all these cases have been essentially about the effect of an annulment of a Commission decision on the subsequent conduct of the Commission. But erga omnes only in the sense that it's not open to somebody else to say, well, I wasn't in the original proceedings and I'm asking the Commission to do something different. Because the whole purpose of this exercise is to regulate the compliant relationship between the Commission and the court, where the court has laid something down that's relevant to the Commission's conduct. Now, the present case, as I understand it, doesn't involve the Commission at all. It's a private piece of litigation between the health services in question and Servier going on in the UK, in which the Commission has no ongoing role. Are you going to show us cases in which erga omnes has been applied outside the context of what is necessary properly to regulate the conduct of the Commission?
So three answers to that. First of all, my lord, you're absolutely right to say that Perez-Diaz and Asteris were concerned with what the Commission had to do.
P&O, I think.
P&O was indirectly concerned with the same point, but the actual point that was prohibited by res judicata wasn't in that case in terms what the Commission was doing. The point at which that came into conflict with res judicata was an argument raised by a non-party in the subsequent case. So that's the point at which there was a conflict with res judicata. The Commission was doing its job. There was no question about whether the Commission had implemented correctly. Rather, the question was, the Commission having implemented it correctly, what could then be said in a subsequent case brought against the Commission's decision? So it was connected to the Commission's decision. You're absolutely right, but it wasn't exactly about what the Commission has to do. In that case, what was an issue was not directly the Commission's the invalidity of the Commission's implementation, but rather whether this particular argument could be raised. The second point to make is that in the Artagodan case, which is exactly the case I was going to come to, that's not about implementation at all. It's about damages action. And I'm sure the claimants will say, well, this is a damages action brought in the European courts. The present case is brought in the domestic courts. That's really the point of distinction. But Artagodan makes absolutely clear that it can, Mr. Turner shaking his head, well, he'll make whatever submissions that he's going to make. But Artagodan makes clear, and it wasn't even disputed, it was assumed as being correct, that res judicata could apply in the context of a damages action. And the question is, then was simply what was res judicata in Artagodan. But there was no disagreement about whether the principle applied. So that's the second answer to your question. The third answer to your question is that you are right to say that all of these cases are on their factual context slightly different in different ways to the present case. Some of them are cases involving the Commission. Some of them are cases involving damages in the European courts against the Commission. There is no case that is on exactly all fours to the present case, and that is really in a way the reason why we're here. we don't dispute that there is no case that is precisely on all fours with the present case. There are several reasons why that's not surprising. One is that it's actually relatively rare for a competition case to be annulled at all in the European Court. So, and there are only a handful of examples where that's the case. So you wouldn't expect to see many cases in where there had been a finding that might be then res judicata in the domestic courts. The other point to make is that actually in the domestic courts, in the UK courts, at least, it's also relatively rare for a competition case to make it to trial, and that's only really started to happen in the last couple of years. So it's only in quite recent times that the sort of juxtaposition of events has occurred, which raises this question. And that's why this question is being raised now. And the reason why this case has got this far is that there is no direct and all fours comparator, but the statements of principle made by the European courts are never limited to the facts before them. The statements are made in quite general terms. So if there is some limiting principle, that's not a principle that's been articulated in terms by the European Court, who talk generally about res judicata erga omnes and apply that principle in a variety of different situations and contexts. And the Artigodan case is the one I was going to come to, and that's the damages case. And this is at tab 9 of the authorities bundle. And it may, my lord, answer at least in part your question. The judgment starts at page 1208. And this arose in the context of the annulment of the Commission's decision to withdraw various marketing authorizations for slimming pills. And the General Court had annulled the Commission's decision on 2 grounds: lack of competence to adopt the decision and a breach of Article 11 of the relevant directive setting out the conditions for grant and also revocation of a marketing authorization. And on appeal, the CJU upheld the lack of competence point and said that it therefore didn't need to rule on the Article 11 point, the other point. And Artigodan, which was one of the slimming pill companies, then sued for damages, sued the Commission for damages. And in the context of discussing the sufficiently serious breach issue, the question arose as to what had become res judicata following the earlier judgments. Now, the rest of the case is set out in our written case and also in the Court of Appeal's judgment. So I can just take you to what the CJU said on appeal.
Just for clarification, so the case was a case where a party was seeking to get the Commission to do something, namely to pay damages.
Well, yeah, in that sense, yes. It was a case involving the Commission, but it was a damages action, and it was a damages action arising out of the earlier annulment judgment. Yeah. So the Commission had annulled, the Commission had withdrawn the slimming pills, it was said unlawfully. The General Court, and ultimately the CJU upheld that, and the damages action was then brought on that basis. So it's a damages action. I entirely accept a different kind of damages action to the present, but the point that is important is that in the different context of a damages action, there is no question in the mind of the court that the principle of res judicata applies. The issue which came before the courts here and which gives rise to some quite important statements of general principle is what the scope of the res judicata was. If you pick up at page 1220, paragraph 86, this is quite a nice summary. Paragraph 86 and paragraph 87, in fact, together are quite a nice summary of the underlying purpose of the principle of res judicata. And you'll see that that doesn't make any reference to the principle arising in a particular legal context that concerns the Commission. It's quite general principle concerning the stability of law and legal relations, the sound administration of justice, saying that it's important that judicial decisions which have become definitive and so on can no longer be called into question. And then at paragraph 87, a restatement of the scope of the principle referencing P&O. Firstly, that res judicata extends only to the matters of fact or law actually or necessarily settled by the judicial decision in question. And secondly, that the force of res judicata attaches not only to the operative part of the decision, but also to the ratio decidendi of the decision, which is inseparable from it. And just pausing there, this is the best single authority that I found setting out the purpose of the res judicata erga omnes principle. The claimants have characterised that purpose in their written case at paragraph 54 as being to prevent legal questions which have already been settled from being referred back to the court for re-examination. And they get that from paragraph 41 of the P&O judgment. But the court has made clear in this case and others that the principle extends to factual assessments. And if I can paraphrase what's being said in these two paragraphs in one sentence, what the court makes clear is that the overarching purpose of the principle is that in order to ensure the stability of law and the sound administration of justice, the matters of fact and law that are actually and necessarily settled by the decision and which constitute the ratio of the decision can no longer be called into question. So that's a one sentence paraphrase of what's being said in paragraphs 86 and 87 of this judgment. And in the next paragraphs of the judgment, the court concluded that the factual and legal findings related to the lack of competence issue were res judicata, but the Article 11 point was not, because the CJU had not ever ruled on that. It wasn't necessary for it to do so. And you can see the conclusion at paragraph 93. It follows that the General Court erred in law by holding in paragraphs 44 to 48 that the factual and legal findings in the judgment of the General Court in Artigodan concerning the infringement by the Commission of the conditions for withdrawal set out in Article 11 have, in the same way as the factual and legal findings relating to the lack of competence of the Commission, acquired the force of res judicata. So the General Court had found that both sets of findings had acquired res judicata, and the CJU on appeal says no, the Article 11 point didn't have the force of res judicata.
I'm finding this a little difficult to follow. So the taking of the appeal against the General Court's decision,
Yes,
deprived its finding about Article 11 of the force of res judicata, even though the point wasn't addressed by the CJ, by the Court of Justice.
yes, it's rather odd, and it's probably not the way that an English lawyer would look at it, but that's the way that the court approaches it, and that was what was determinative in this case, because the Artigodan wanted to rely on the finding having been made by the General Court at first instance and settled. When the damages action came along, the CFI agreed, but found for other reasons that there wasn't a sufficiently serious breach. But the CJU said that was not the case. The only finding that was res judicata was the finding on lack of competence, because that was the basis on which the CJU had upheld the appeal. For reasons which which are peculiar to EU law, it found that the Article 11 point wasn't res judicata, and that's all set out in the Court of Appeals judgment. But for these purposes, the point that this underscores is that in a damages action, there wasn't any dispute that the principle of res judicata applied in principle.
Yes,
and
the damages action based on the Commission's response to the annulment decision.
yes, but I should add that it's not disputed in this case, or at least it's set out in the Court of Appeals judgment that res judicata does apply in this case, but only to the extent of the infringement finding. So the Court of Appeal makes clear, And this is I'll just give your Lordship's reference. It's a paragraph 70 and 71 of the Court of Appeal judgment. There's not a question about whether res judicata in principle applies in this damages action. So as far as the Court of Appeal is concerned, it is settled and established by these cases that res judicata will apply in this domestic damages action and will preclude the claimants for the purposes of their infringement case from disputing the findings of the General Court. So the claimants can't raise the Article 102 case in these proceedings. The point of difference between us and the Court of Appeal is whether those findings are also res judicata for the damages part of the case. And that, as I understand it, the claimants don't dispute. Indeed, the claimant's written case refers in terms to that part of the judgment of the Court of Appeal. And that, just to give your Lordship's reference, it's paragraph 49, subparagraph I of their written case at page 17, internal page numbering of their written case. The settling of that issue precludes any subsequent attempt to pursue a case of abusive dominance against Servier based on the Commission's finding that there's a relevant product market limited to perindopril. So I was just reading from the claimant's written case. So our understanding from the Court of Appeal judgment and indeed from the claimant's case is that there isn't a dispute that in principle the EU concept of res judicata applies equally to the present damages proceedings. So we have an example of it applying to EU damages proceedings. We say there's nothing in any of this case law to indicate that the same shouldn't apply to domestic damages proceedings. And for the reasons I've given, we don't have, if we did have an example of that being done by the European courts, we wouldn't be here today. We're here because that hasn't been done in terms by the European courts, but there's no reason of principle why the statements, the unambiguous statements that are made in those cases, which are not limited to, say, damages actions against the Commission or actions involving the Commission, there's nothing in those that say erga omnes doesn't mean erga omnes, it means only erga omnes as long as the Commission is involved in the proceedings in some way. And that's why we say that in principle, this case does fall within the statements made by the European Court as to the scope of the principle of res judicata. We accept that the position may need to be referred, and we've asked for a reference from this court. But on its face, on their face, the European case law, the judgments of the European case law and the statements of principle in that case law does not exclude this case. And the judgments are expressed in quite general terms, as you've seen. As I said, I think the statements in 86 and 87 are probably the best overarching summaries of the principle of res judicata and its purpose. So that's 86 and 87 of Arta Godan. Certainly, I've not found a better all-encompassing summary of what the principle is doing, and that makes no reference to any limitation that the claimants are pleading in these proceedings. So, my Lord, I was then going to go on to the shoe branding case, and that was the fifth of the cases that I wanted to refer to. And that is a case that's extensively discussed in our written case and, of course, the Court of Appeal judgment. And so I can take that quite shortly. There are two relevant points to be made from that case. This is a case at tab 11 of the authorities bundle, starting at page 1237. Of the electronic file. Now, the two points to be drawn from that case. The first, which I believe is now accepted by the claimants, is that what is res judicata in an annulling judgment can in principle include factual assessments on points of detail. So that I don't understand the claimants to be disputed as a matter of principle. They say that's true, but with strings attached. The second point, which is disputed by the claimants, is what this tells you about the scope of the principle of res judicata. And the key passage in that case, which I'd like you to look at, is paragraphs 99 to 105. And the factual assessment that was res judicata in that case is identified in paragraph 100. And that is the point about the degree of attention of the relevant public, the average consumer, and the point that the average consumer has an average degree of attention when purchasing the sports shoes in issue. And the court identified that and another finding as being res judicata in paragraph 100. Said that was res judicata with absolute effect, and that's the following paragraphs summarise the case law referring to P&O among others, and concluded that the applicant could therefore not challenge the merits of the new decision regarding the degree of attention of the relevant public. Conclusion you'll see at paragraph 105, it's not open to the applicant to challenge the merits of the Board of Appeals assessment regarding that particular point. And again, none of this suggests a principle that is confined in the way that the claimant suggests. Of course, on its facts, it was a case about 2 successive decisions of the Board of Appeal. But the principle as expressed here, the principle of res judicata, is it not expressed to be conditional on the particular factual situation of that case. There's one other side point that I wanted to make about that, just about terminology used here. You'll see in paragraph 103 the words necessary support constitute the necessary support for the operative part of the judgment. And you'll have seen that in asterisk at paragraph 27, the phrase used is essential basis. And that's a point that I made to the tribunal in the Trucks case. And as I explained there, and the tribunal agreed with me, those 2 phrases are used interchangeably by the European courts. And they're just 2 different translations of the same French phrase, which is soutien nécessaire. So sometimes it's translated as necessary support, and sometimes it's translated as essential basis. And so they mean the same thing. And just to give your lordships the reference, that's at paragraph 58 of the Trucks judgment at Authorities tab 34. So having looked at the key authorities, I need to make 2 important points about what's going on in these cases. The first is that what we see in these cases is a rule of EU law that applies specifically to annulling judgments. And the reason for this particular rule about annulling judgments is given in the first sentence of paragraph 3 of P&O, that an annulling judgment leads to the retroactive disappearance of the act that is annulled. And that must take effect erga omnes, not just for the parties to the judgment or even for the Commission. And that's why in this case, there is no question of the res judicata attaching to the annulling judgment in principle not being engaged in the damages actions in these proceedings. Whether the court is deciding mitigation or causation or whatever part of the domestic case, the fact of the annulment of the 102 decision cannot be called into question. And the claimants cannot therefore state in whatever part of their case that Servier's conduct has been found to infringe Article 102. So that's the first important principle. And annulling judgments have a particular effect, and it's an effect that takes effect erga omnes, and that really does mean erga omnes, the whole world. The second point is that it's important to understand why that erga omnes effect extends into the reasons that are the ratio of the judgment. And the reason which you again see particularly in P&O, but also in Artagodan, is that the court regards the ratio as being inseparable from the operative part. And it's inseparable because it defines in an essential way the scope of the operative part. In other words, and these are my words, it's as much the decision as the operative part. So when you talk about the decision, it's not just what's said in the operative part, but to understand what that decision is about. You have to look at the ratio, and that's what the court is saying. So whoever is bound by the judgment needs to understand and needs to know the scope of what it's bound by. And we can see from the case law that that is true, whatever context the issue of res judicata comes up, whether it's the Commission implementing an annulling decision, and those are the examples given by my Lord Briggs, Asteris and Perez-Diaz, or whether it's somebody, whether or not a party to the original case, raising a point challenging a later decision, and that's P&O and shoe branding, or whether it's someone bringing or defending a damages action in relation to the conduct that's the subject of the original decision, and that's Artagodan. They all need to know the scope of what is binding, the scope of the decision that is binding on them. And there's another practical reason for this, which turns on the way that European acts are framed, and that's that the operative parts of annulling judgments are typically quite short, and they're confined simply to saying that the relevant decision or whatever is set aside. So if you didn't extend res judicata to the essential grounds, what you would see is parties making exactly the arguments that arose in cases like P&O and Perez-Diaz, that all that's binding on them is the final decision on the specific point and issue in the annulling case, which they would say doesn't apply to them. And what you have seen in these cases is that the court has completely rejected that type of formalism. The relevant question, it's said repeatedly and consistently, is not whether the two decisions have the same subject matter, whether the two judgments have the same subject matter. The relevant question is whether the point in dispute is part of the ratio of the annulling judgment, in that it forms, in the asterisk test, the essential basis or necessary support for that judgment. And that's all there is to it. So it's a rejection of the formalistic approach of looking only at the annulling judgment and what the subject matter of the annulling judgment is, and replacing that with a test that simply looks at the ratio and saying, does that conflict with something that is an issue in the subsequent case? That might be a convenient moment to take a 5-minute break if that suits your lordships.
Yes, certainly. Thank you, Ms. Bacon. We'll adjourn now and sit again in 5 minutes' time. Ms. Bacon,
yes.
If you're ready to resume your submissions.
Yes, can I come back on a point of detail arising from your lordship's question about the Commission survey?
Yes.
I've been given some further points by my instructing solicitors that I think that I just need to make so that there's no doubt about what was going on here. The first was that the Commission's decision wasn't an aggregate EU decision, but looked at specific individual markets in France, the UK, the Netherlands and Poland for the supply of perindopril. Now, we don't have the relevant paragraphs of the Commission decision in the bundle, but that point is made in the English claimant's particulars of claim. It's at page 260 of the electronic bundle at paragraph 45C. And it was said that Servier was dominant on each of those, so that the general court's findings were not in some way aggregate, but were applicable to each of those markets individually. That's the first point. The second point of clarification was that actually a lot of the evidence, and I've said that it wasn't just the survey, a lot of the other evidence came specifically from the UK. And I think I made that point to you before the break, but I just wanted to give you one reference for that. And that's in the General Court judgment at paragraph 1421. We don't need to go to it, but just so that you have that, because it referred in terms to policies, for example, implemented by local authorities in the United Kingdom. That's at page 793 of the electronic bundle. I understood that Lord Lloyd Jones had a question.
Well, sorry, just before. So the way it's put in your, well, in the statement of facts and issues on page 59, electronic, is in terms of a number of paragraph 21, a number of 8 propositions derived from the General Court judgment on which it's intended to rely as binding, and they're put at a level of generality.
Yes.
And by reference to paragraphs in the General Court judgment.
Yes. So the point that I'm making is that those findings, which are put at some level of generality, were being applied individually to the different markets, including the market of the UK, because that was what was being annulled. So those findings were specifically and individually applicable to the UK. They were specifically applicable to France and so on.
Yes. Well, this might be. Well, it's quite interesting. So the findings are general, and your point is that because they were applied to a specific market of the UK, therefore they are to be taken as binding findings of fact in respect of each of the UK jurisdictions which the domestic proceedings are concerned with.
Yes, because the findings are not simply put at a level of generality about the whole of the EU, but because of what the General Court was doing, it had to look at the specific markets in which Servier was said to be dominant, which were individual markets, not an aggregate EU market. So I think that's just an important clarification to make, in case it should be said that the market was somehow a different one.
Thank you. I'm sorry, I interrupted when somebody else was about to ask a question.
Not at all. Not at all. If it's a convenient moment. Ms. Bacon, just before the break, you made your first submission on the basis of P&O paragraph 3, that the fact of the annulment of the Article 102 decision cannot be called into question in the national proceedings. Can you help me, please, as to how the claimant's pleaded case calls it into question the General Court's decision in relation to Article 102?
No, it's not our submission that it does, and at the moment, because we're still waiting for the CJEU judgment, I don't believe that the claimant's pleaded case has removed the Article 102 elements. So the original pleaded case does rely on Article 102, but we're not taking a point on that because the claimants have confirmed in terms that they are not going to pursue the Article 102 point, or indeed the Kirker agreement point that was also annulled by the General Court. So
my question is, forgive me, is directed at something rather different, and I understand that point about the issue on Article 102 being a matter pending before the Court of Justice. My question is rather how the prescription point, the pleaded prescription case, calls into question the General Court's decision.
Yes, well,
in relation to abuse of dominant position under Article 102.
Yeah, the claimants say that they aren't going to say that anything that's contrary to that. They're making different points. However, as Mr. Justice Roth said, we want to rely on the propositions that are in the General Court. And the propositions that we extract from that, which are, as my Lord Reid has just noted, are general ones, those propositions are not accepted as a matter of fact by the claimants. They are disputed by the claimants, and their evidence goes to those issues. So that's why this is relevant. There will be an evidentiary dispute between us and the claimants, which will engage the propositions that we rely on. Now, of course, I don't dispute that the claimants are going to raise lots of other points, and they're going to say that these aren't determinative, but there is an evidentiary dispute. And I should also say, a point that I was going to come on to, that the claimants do plead reliance on the Commission's decision in general, and also in relation to their mitigation case.
can you just help me on this? I understand that at an earlier stage there was pleaded a claim against you in an economic tort,
Yes.
and that's been struck out, and there's an appeal pending in relation to that. But
Yes.
presumably, if presumably your submissions would apply equally to the claim in the economic tort.
They would, if it's all part of the same proceedings. They would in principle, because the case engages EU law. At the moment, we haven't had to grapple with that issue. It may be that the claimants say that if the economic tort point springs back into life, and I think they do say this, if that springs back into life following whatever judgment is given by this court, then there will be a question about whether the mitigation points on that are somehow different. Now, in my submission, it would be quite difficult to say that the case on mitigation is different for the economic tort if it's been already determined. And that's a point about, that does raise a point about sequencing, because at the moment, the preliminary issue trial is scheduled to take place before we will have had a judgment on the economic tort issue. So it is slightly procedurally complicated, but I would say that that's a submission to be made somewhat down the line. At the moment, it doesn't arise. At the moment, where we are now and where we will be at the preliminary issue trial is that the preliminary issue trial will concern mitigation in relation to a case that doesn't at that point have the economic tort issue in it.
But the scope of your submission would seem to lead to the conclusion that it should apply equally to the economic tort.
In principle, yes, because it's part of the same proceedings and mitigation applies across the board. If there was only, and maybe I could put it in this way, if there was only an economic tort argument and there was no EU law claim at all, then we wouldn't be making the submission of res judicata, because we have all accepted that the principle of res judicata applies only in a case to which EU law applies, in a case in which EU law is engaged. And that is a key limitation that we have always accepted, forms one of the boundaries.
And you say that EU law is engaged in this case. Clearly it is, because the statutory cause of action on which the claimants rely is the statutory cause of action in relation to infringement of competition rules, but under Article 101, not under Article 102.
Yes, at the moment under Article 101, because the Article 102 case won't be pursued. But as I've said, I mean, if that's the point of distinction, that again is one that is not really suggested by the case law, because the case law makes clear in the P&O that the subject matter of the cases doesn't have to be the same. So in terms, the argument about Article 102 and 101 is the kind of argument that the court has rejected. But in any event, as I explained at the outset, what is notable in this case is actually the Article 102 and the Article 101 cases are based on the same set of facts. They're based on the same agreements. And the case is just put in different ways by the Commission. That it was both an abuse of dominance and a unlawful agreement and infringement of Article 101 to enter into those agreements. So it is about the same conduct. So it's not really a case where the subject matter is different. The most that can be said is that there are different legal characterizations of the same set of facts. One turns on Article 102 and requires a finding of dominance. The other turns on Article 101 and doesn't.
Thank you very much.
Can I just pursue my point a little bit further? What was the market that was being analysed by the Commission, in which Servier was alleged to be dominant?
The market in each of France, the UK, the Netherlands, and Poland.
I see. Right.
Set out in the paragraph of the particulars of claim that I referred you to.
Yes. And so. So you would say that, read in context, a statement such as the one you rely on, that ACE inhibitors are widely perceived as substitutable by prescribers, read in context, written context, you say that's to be understood as a proposition of fact about the UK market.
Yes, and a proposition of fact about the French market and about the other markets. Yes. I would. We say fact. I mean, we're always using the terms fact and law in these cases. Of course, all of these findings are really. You could describe them as factual findings, and we don't demur from that characterization. But lots of these could be described as mixed fact and law because they're factual findings that go to specific legal points and are relevant findings because of the case law.
Yeah. And then where does it take you? Widely perceived. I mean, in terms of your arguments about either mitigation of loss or contributory negligence on the part of, say, the Welsh ministers.
Yes, but these are the building blocks. They don't completely answer every single issue that's likely to arise in the preliminary issue trial, but they are going to be.
You're asserting that statement has to be understood as being true of Wales.
Yes, because it's referring to the UK, and as I've said, what
you
the
can't differentiate between Wales and Scotland, for example.
Well, actually, the claimants are seeking to differentiate on a much more granular basis and are saying that in different considerations were taken into account in different primary care trusts.
Yes, I rather expect they would be. I mean, they're different administrations. Anyway, right, thank you.
So can I just turn now to the claimant's central objection to our reliance on the principle of res judicata, and that is their thesis that the concept is only engaged where the subsequent proceedings concern the issue that's already settled by the EU court. And there are three initial answers to that question. The first is the one I've given you. There's not a trace of this limitation in any of the EU case law. None of the authorities I've shown you contain the limitation that they seek. The second, again, a point I've made to you, the CFI and the Advocate General in P&O made the point about res judicata depending on whether the subject matter of the cases was the same, and the CJU expressly rejected that. The third point is that conceptually, if there were that limitation, it would be question begging because you'd have to then determine what was the issue that has to be the same. We know that it doesn't have to be the same decision. And we know that it doesn't have to be exactly the same legal context because we've seen res judicata being applied in a damages context. And we know that res judicata can go into a different decision, be applied to a different person, Perez Diaz. It can concern aid paid in a different year that was subject to the annulling judgment, and that's asterisk. And that's a practical reason why it's not surprising that the court's test doesn't try and identify the identity of the issues or the subject matters, but simply asks what are the findings that are the ratio of the judgment in question. And the claimant's answer to all of that, or attempted answer, refers to the Assi Demen case. And the claimants say that that shows that you can't borrow from one legal context to another. And Assi Demen's at tab 5 of the authorities bundle, and it is, as the claimants say, a very well-known judgment, and it established that a commission cartel decision addressed to a number of companies is regarded as a bundle of decisions, one for each specific addressee. So in consequence, if one addressee annuls the decision for them, the commission doesn't have to withdraw or rewrite that for the non-appealing addressees. And the claimants say that this is the case that shows that the underlying findings in the annulling judgment could not be transferred to a different legal context. In that case, the legal context of the fines imposed on the non-appealing parties. But there is actually nothing in the judgment that supports that proposition. And if that were right, it would have applied equally to Perez Diaz. Mr. Perez Diaz couldn't then have relied on the judgments in the other two ladies' cases based on the grounds that he hadn't advanced. The reason why in Assi Demen, the non-appealing Swedish producers couldn't reopen the question of their fines was twofold, and both reasons are set out in the court's judgment. The first is set out at paragraph 55 of the court's judgment, which is at page 1044 of the electronic file. And in that paragraph, the court notes that the annulling judgment had not decided anything whatever in relation to the non-appealing Swedish producers. And the same point was made by the Advocate General. You don't need to go to it. It's a passage at paragraph 54 of his opinion, which we've cited in our written case. And just to give you, your lordships, the reference, it's at page 1020 of the electronic file. And he said that the problem was not that the annulling judgment hadn't taken effect erga omnes, but that what it decided, having regarded to the divisible nature of the collective decision, was strictly limited to making findings about the specific infringements of the appellant and not the infringements of anyone else. So that was the first reason why the appellants in the Swedish producers in Assi lost. The second and equally important reason why they lost was just that they were out of time and the decisions against them had become final. And that point set out at paragraphs 57 to 63 of the Assi judgment. And that's pages 1045 to 1046 of the electronic bundle. So if in that case, the findings in the annulling judgment had decided something about their conduct, and if the relevant decisions hadn't become final and definitive, the result would have been different, as you've seen from both Asteris and Perez-Diaz. So this wasn't a case about borrowing or transposing or non-borrowing or non-transposing. It was a case about the findings originally not really applying to the appellants in question, and a point about their appeals being out of time.
Can I just take you back, Lord Briggs, again to paragraph 55, which is your first point.
Yeah.
And it's really the second sentence you're relying on, as I understand it.
Yes.
But what it says is the authority of a ground of a judgment annulling a measure can't apply to the situation of persons who were not parties to the proceedings and with regard to whom the judgment cannot therefore have decided anything whatsoever.
I think that's very interesting wording. I picked exactly the same point up, my lord. That kind of implies if you take it semantically, if you parse it semantically.
I agree.
It does imply that if you were not party, then the judgment didn't decide anything whatever for you. But as I've just said, that can't be what they mean because of Perez-Diaz and Asteris. And also, if you that particular point needs to be read together with exactly the same point made by the Advocate General. And I have come to the conclusion that that's simply slightly loose wording, because the Advocate General makes exactly the point that nothing was decided against the Swedish people because it was a separable, separable, divisible decision. He makes a point in paragraph 54.
There's nothing wrong with the translation, is there? This probably wasn't the language. This probably almost certainly wasn't the language of the case.
No, I don't think it was. And I looked at the translation, and it seems to be correct. But I think that to place decisive word on the word therefore is giving the therefore too much work. If you read that in context, firstly with what the Advocate General says, because he is making exactly the point that I draw out of that, particularly on the anything whatever. And secondly, if you read it together with the other cases, and of course we know this was before P&O. It was before P&O, but after I think after Asteris, or maybe around the same time as Asteris.
It's the Grand Chamber judgment.
I'm sorry.
I noticed. I haven't checked how many judges sat on the staff case, but I doubt whether it's comparable. This was a case with the president of the court presiding over a Grand Chamber.
Yes, and the P&O was also, I believe, decided by a Grand Chamber. I think so, or at least in an extended
I'm not suggesting. I was thinking of I was contrasting it with the Perez Diaz case, which was that was a single judge.
But we know from P&O, which succeeds this case, we know from P&O that the parties to the proceedings point is not decisive, because that's the point that the court in P&O rejected in terms, and because the specific point and issue there was raised by the local authority, which had not been party to the first proceedings. So there are a number of reasons why I would say that therefore can't be decisive in this context when read with everything else.
Yes, but that was a case concerned with the Commission's response to an annulment decision.
Yes, and the point was really the point and issue was whether the Commission had to reopen decisions in a load of other cases which hadn't been appealed, which had become final. It's a point about being out of time. When the court was saying, and you'll see the same point made in the Advocate General. What was decided in the annulment decision did not address the specific situation of the Swedish producers, and that's anything whatever. And the only explanation I can give for the therefore was that we are talking about this specific case, that in circumstances where you do have, as the Advocate General put it, a divisible decision, so you have a bundle of decisions, what the court may be saying is, in those circumstances, if you are an appellant who never appealed, if you're a party who never appealed the original decision, that when you have that type of decision, the annulling judgment cannot therefore have decided anything about you, and that would be entirely consistent with what I'm saying about the case. So can I then move on quite swiftly? I've got a little bit of ground to cover after all those questions, and I don't want to finish too much over time. I've got two big headings to cover before references. Firstly, whether our propositions are essential basis. We've essentially set that out in our written case. I don't need to take you through all of that, just to say that we can now look at two pieces of guidance as to what is essential basis in terms of factual assessment. One is shoe branding, which refers to a very specific factual assessment, which is in a way much more detailed than the ones that we rely on. The other is the tribunal's recent judgment on binding recitals in the trucks litigation, and you will have seen from that, and if I can just give you the reference at paragraph 148 of the trucks judgment, which is at authorities tab 34, the tribunal set out a series of quite granular findings of fact that it considered formed the essential basis of the infringement decision. And so that gives a good guide to how you go about doing this in practice if you are doing it as a domestic court. Now, the claimant's objections to our four findings and the question about whether they are ratio boil down to essentially two arguments. The first is that they're not essential, and that without any one of them, the overall conclusion could have been adopted. And we disagree with that for two reasons. The first is that the decision in this case rested, in fact, on a structured series of propositions, as we've set out at paragraph 20 of our written case, and each one of them built on the last, and they're all necessary to support the final conclusion. The other reason is that what the claimants are essentially saying is that the court could have annulled the decision on the basis of different reasoning, but that's not the question. The relevant question is what findings are necessary for the reasoning that the court did adopt as the basis for its decision, and that's what we've set out in our written case. That's the first objection. The other objection to our findings is that they are, the claimants say, evaluative and imprecise. And the answer to that is that's simply in the nature of identifying the key reasons for the judgment. They will necessarily include some quite high-level conclusions, and by definition, they will be based on the evaluative assessments of the court. The detailed reasoning is set out in the rest of the judgment, and we're not saying that all of that is an essential basis, not least because it would deprive the concept of any useful function. When it comes to evaluative findings or imprecise findings, the findings in the trucks case were even more broad brush and imprecise in our submission. So we say that the 4 findings on which we rely are precisely the sort of findings that can be regarded as a central basis. And they are the central findings for the reasons that we've given in our written case that underpin the conclusion on market definition. So that's a short summary of what we say about those 4 findings. The next point is the practical difficulties or boundaries point. And in our submission, the trucks case is a complete answer to those points, because the exercise that we're suggesting is a much more confined exercise than the tribunal carried out in trucks. We're talking in this case about 4 relevant findings. In trucks, the tribunal had a total of 39, I believe, disputed recitals before it. And the trucks case also shows why the findings that are used to establish infringement of the competition rules and the findings that are relevant to the damages assessment are inextricably related. Because the reason why the issue of binding recitals arose at all in that case was that establishing what conduct was an issue and how that conduct impacted on competition in the market was inevitably a central issue and recognised to be a central issue in any damages assessment. We of course acknowledge that the nature of an infringement inquiry is different from the nature of an inquiry into damages. But in trucks, the tribunal drew upon European court jurisprudence, in particular the Air Canada case, and it rightly recognised that the same facts will be relevant to both. And there is therefore no question of uprooting or the transplanting the facts. It's one and the same set of relevant facts that the tribunal and the European court have both acknowledged go to one and the same decision. And as I said earlier, the claimants in this case have specifically pleaded that they will be relying on the Commission's findings in the decision as binding on the court generally for their damages claims. And they also, all of them, rely on the decision either directly or indirectly in relation to the mitigation point. All sets of claimants either cite the Commission directly in their mitigation parts of their pleadings, or they refer back to what they've said elsewhere, which in turn relies on the decision. So the claimants are squarely relying on the decision, and no doubt the claimants will in due course rely on the trucks case to extract the findings in the decision, which they say are the essential basis for their damages claims. But at the same time, they're saying that the findings by the European courts, a higher authority, concerning that same decision can't be binding because they relate to a different subject matter. So their argument really is saying there should be source for the goose, but not source for the gander. And we say, well, there should be source for both. Paragraph 79 of the claimant's written case itself explains why it would be anomalous for there to be a divergence here, and that the claimants say in terms paragraph 79 of their written case that there is a shared competence between the Commission and the national courts to apply the European competition rules, so that where the national court is considering precisely the same agreement under the EU competition rules as the Commission has done, in order to rule on the civil consequences of the infringement, the essential reasoning of the two bodies should be fully consistent to prevent incoherence in the EU legal order. That's their case. And we agree, and we say that the same applies equally to the findings of the European Court when annulling partly the decision of the European Commission that is relied on in this context. Now, there are, of course, questions about the potential boundaries of the principle. And in our submission, this court doesn't need to decide those exhaustively in these proceedings. This particular case should, in our submission, fall within the existing case law, given that this is a case of damages arising from the Commission decision that was the subject of the annulling judgment, with Servier as both the party to the European proceedings and the defendant in domestic proceedings. But if further boundaries do need to be set, and the court has got further questions about as to the limits of the principle of res judicata, and Lord Lloyd Jones's question about the economic tort hypothetical at the moment, but that may arise. That sort of issue cannot be said to be acte claire, and that raises the reference point that I will come on to shortly. Now, just before I get to reference, there's just a footnote on French law. We are obviously not asking this court to delve into the complexities of the different types of res judicata that may or may not arise under French law. Our point was a very simple one, and that's that while the EU concept of res judicata erga omnes may be different to the way that our common law system approaches the question of res judicata, this is one of the respects in which the court may have drawn more heavily on the approach in civil systems. And we've seen that in that regard, that similar concepts do arise in French law, and that's all we're saying. So can I come then in the last few minutes of my time to the question of the reference? My Lord Briggs.
In trucks, the application of facts found by, I can't remember if it's the commission, wasn't it? Yeah. Isn't based on res judicata erga omnes, is it? It's based on section 58A(2) of the Competition Act. Am I right?
Article 16 of Regulation 1 of 2003. Yeah. So that's why the Court of Appeal in its judgment explained that the route by which we get to the applicability of the relevant decision is different. Yeah. And that's why my case is not the following. Truck says that you can apply the commission decision, yeah. Therefore you can apply the European Court. I'm not saying that, because the route is different. We're saying quite squarely you apply the European Court on the basis of the principle of res judicata, not Article 16. The reason I referred to trucks is to show you why it is entirely possible to do exactly this exercise.
Okay, I won't delay you any further. Thank you very much.
That was all. Reference. So our overarching submission, as you will have seen, is that the position cannot be said to be acte claire against Servier, and this court should therefore refer the matter to the CJU. There is no doubt that it's necessary to resolve one way or the other the issue of whether the findings of the General Court are binding on the domestic courts, and the issue has to be resolved before the preliminary issue trial takes place. Now, in terms of when that should be decided, given the CJU appeal, that was the subject of the submissions before Mr. Justice Roth at the hearing in March. And I do invite you then to turn up his judgment on that March hearing. And it's at tab 33 of the authorities bundle. Because what happened at that hearing was that I made precisely the point that is now being put in issue against me, because I said, well, it's premature to decide the issue of what's binding until we have a judgment of the CJU determining the appeal. And Mr. Turner made the opposite submission. He said, no, get on and decide what's binding now, irrespective of the appeal. And that's
whoever said what. We have to apply the treaty, and we can't make a reference unless it's necessary for us to make one.
Yes, my lord, I was going to get to that, because essentially this was a case management decision, and the case management decision of Mr. Justice Roth was that he considered that as a matter of case management, the issue of the bindingness of the recitals should be decided now, irrespective of the appeal. And he agreed with Mr. Turner at paragraph 12. He said he accepted that if the hearing proceeding now, it will involve looking at the General Court's judgment, but the hearing, if it proceeds, would not be on hypothetical facts. We have the judgment of the General Court and the findings made, and this court can determine the general principles of res judicata as applicable under EU law. So he considered that if the findings were binding, so at paragraph 14, if he decided that the findings of the General Court were binding, he recognised that the October trial couldn't proceed, so we'd have to await the CJU. That was a point I made earlier this morning. So as a matter of case management, he said, if he decided that the findings in principle were binding, we would then have to wait for the CJU. But he said at paragraph 16, even if the appeal was successful and different findings were made, the same principles of res judicata would apply to those findings. So it's going to be necessary to decide the point in any event. It might simply be that the question of how it applies is applied to the findings of the CJU if they are different to the General Court. But the question about whether res judicata applies has to be decided. And that was to answer my Lord Reed's point. That was a case management decision then about whether to proceed with this whole issue. And
what relevance is that to us?
Because that case management decision hasn't been appealed, and that's why we're here. And
but we're in a completely different position from Mr. Justice Roth, because we're a final court of appeal.
And furthermore, Mr. Justice Roth was case managing that issue as before him. He surely wasn't case managing how that should be dealt with by any subsequent reference, if anybody suggested there should be a reference.
No, I mean, he was saying the issue has to be decided, so let's get on and decide the bindingness issue, and that's why it's come before this court. There's no question that it needs to be decided one way or the other. The only question is one of time.
Who knows? I mean, if your four propositions were all held by the CJAU to be unfounded, then the question falls.
Yes. Well, if you like, that's a hypothetical future event, and one of the reasons why we put the case of Telia in the bundle, and that's it's not in the authorities, but it's at main tab 11 of the electronic bundle, is that the court may have a case which turns on various hypotheses, and the court makes the point here. This was a case about a question that was referred on the article of on the interpretation of Article 102, when it hadn't actually even been established in that case that the relevant company was dominant. If the relevant company wasn't dominant, then the CJU's answer would have been irrelevant. But paragraph 15 of the Telia case makes clear that it's solely for the national court to determine the need for the preliminary ruling and the relevance of the questions referred. And the court considered that even in this case, where the national court hadn't even found the primary question of fact about whether the relevant company was dominant, the questions regarding the interpretation of Article 102 should still be decided, because, as the court said at paragraph 17, the answers to the questions referred may be required to enable the Swedish court to give a ruling on the dispute in the main proceedings. So what the claimants are saying is that even though now we have a set of findings which we say will be binding if they're final, they're saying that one of a number of things may happen in the future which may render it hypothetical, but at the moment it's not hypothetical. At the moment we have the General Court's findings, and it's only
but because there is an appeal, there is no question of anything being raised judicata at the moment. There is no final decision. Yes,
but we accept that, and we've always accepted, and it's been common ground that the final issue of res judicata can't be settled until after the CJU has ruled, because then we know what may or may not be res judicata. This court can, however, refer questions about whether res judicata even applies to this case, and it can refer questions on the findings as we currently have them, because those haven't been set aside yet. And the court can either give an answer to that question, or it may already have before it the findings on appeal.
This sounds rather like simply getting us to make a hypothetical reference before the deadline of the end of the year, so there's something in the bank, as it were, just in case it might come in useful.
Well, there is that practical problem, because if the reference isn't made now, it's a
practical problem for you, perhaps, but it's not a practical problem for the court.
Well, at the moment, we have an issue before the court of whether the findings are binding, and it's necessary to decide that. Now, whether the court makes the reference now, if it doesn't make a reference now, the same question is going to arise, and you won't be able to have the guidance of the European Court.
Well, we're going to have to labour under that disability for the rest of our lives after the end of December.
Yes, but this is but the problem is that this is a question that has already arisen in the proceedings before you now, and on
it's only arisen because of a management decision by Mr. Justice Roth, which is effectively been superseded by the appeal to this court.
Well, the management decision was taken at the point in time when the appeal was already known.
Well, in any event, there's no point debating this. I think we're quite clear what the position is.
Yes, my lord. Can I just quickly take instructions to see whether there's anything else I need to cover? All right. My lord, those are our submissions, and I'll make any other points in reply.
Thank you very much, Ms. Bacon. Ms. Turner.
May it please the court, can everybody hear me?
Yes, yes, thank you.
The central issue before the court today is whether there's a point of European law which isn't act clair. The position of the health services is that there is no such point, and that nothing should stand in the way of the trial of Servier's common law mitigation of loss defence. The trial of that issue can't lead to a decision that's incompatible with European law. The High Court and the Court of Appeal were both right to so hold. My lord, the way I propose to organise my submissions is in this way. If it pleases you, first I'll make some immediate headline points to respond to the appellant's case. Then I wish to make an overarching comment about the distinction between the legal issue that was settled by the General Court annulment and the legal issues that form part of our claims for damages in the High Court. Third, I'll address Servier's specific arguments that the Court of Appeal and the High Court got the EU res judicata point wrong. And then fourth and finally, I'll touch on the procedural issue, whether a reference by this court to Europe is appropriate at this juncture in any event. So I'll begin with the headline points, which I will then develop afterwards. The first point is this. There is a clear rationale in the case law for the absolute res judicata rule. The rule comes into play when you have an annulling judgment in EU law. The annulment quashes an act of an EU institution. The consequence is that that act is regarded as void from the outset, ex tunc. The act therefore disappears as against everybody, erga omnes. That is the absolute effect. And the purpose of res judicata is to ensure that the legal question, which has been definitively settled by the annulment judgment in the operative part, is not capable of being re-examined subsequently. The res judicata rule you're considering today extends no further than that. The critical test appears in various places, but I have focused on the last two lines in the P&O judgment in paragraph 41 that Ms. Bacon failed to read, preventing legal questions which have already been settled from being referred to the court for re-examination. Now, legal questions is not the same thing as the subject matter of the dispute. And so, for example, in the P&O case, as the Advocate General pointed out, the second attack there was on a subsequent act of the European Commission. But the point made by the court and by the Advocate General was that the essential point of law being decided was the same point. And the The res judicata principle is there to preserve the integrity of that decision on that point. My second headline point is this, that this rationale and that limitation of the res judicata doctrine is consistent with all of the EU case law which has been shown to you. There isn't a case where findings in the grounds of an annulment judgment have been separated out and bind parties to other litigation which doesn't concern the legal question settled in the annulment judgment. My third point is this. The role of the ratio decidendi of the annulling judgment is that it explains the exact meaning of what's been settled in the operative part. The only reason for looking at the ratio is to understand the exact meaning of the operative part, which you have to understand to determine the consequences. The consequences of the annulment particularly matter because under European law, when the decision of an EU institution has been quashed, that institution falls under a statutory duty to take the necessary measures to comply with the annulling judgment. Originally, the duty was in Article 176 of the EEC Treaty. It moved across eventually into Article 233 of the EC Treaty in 1997 after Maastricht. And with effect from 2009, after the Treaty of Lisbon, it moved again to Article 266 of the Treaty for the Functioning of the European Union, the TFEU, and that is where it is now. Almost all of the cases that Servier has cited to you are, in fact, about the proper interpretation of what is now Article 266 of the treaty. The issue there is, what should the institution whose act has been quashed do to discharge its duty under the treaty to comply with the annulling judgment? And that was pointed out by Lady Justice Rose in her judgment, paras 60 and 61. It shows that in this case law, the underlying findings which give rise to an annulment judgment are ancillary to the legal conclusion in the operative part. They are relevant only as its servants, and they are inseparable from it in that sense. They cannot be transposed in their own right to a different legal context and treated as binding on the parties to other litigation. My fourth headline point is this. Servier's claim that the findings of fact made by the court in the course of reaching its annulment decision can be binding independently, even in a context where the legal question that was settled by the annulment judgment simply doesn't arise for re-examination, and even against third parties who were strangers to that annulment litigation, not only has no basis in judicial principle or authority, it gives rise to basic problems of workability and practicability, as Lady Justice Rose held. And she was right to look at that question in general terms to test the proposition, and not merely to look at the precise four propositions that Servier was contending for. But we say, in addition, that it also offends against the fundamental principle of doing justice between the parties in the case being adjudicated on. All of this underlines the point that Servier's case in this appeal isn't right, and it cannot be right. Now, with those headline points, if I may, I will turn to the overarching contextual matter I said I'd deal with first. In view of Ms. Bacon's submissions, I'd like to bring out the distinction between the legal issue that was settled by the General Court's annulment and the legal issues which do form part of our continuing claims for damages in the High Court following the General Court's judgment. And if I may, I'll begin with the nature of our claims in the High Court. And by our, I'm here also including, as well as the English, the Scottish and Northern Irish and the Welsh health services. So you have claims for damages by the United Kingdom Health Services against a pharmaceutical company arising from the assertion of patent rights. And the health services case is that the company unlawfully relied on its rights to delay competition coming in against Servier's drug, perindopril, from generic versions. That led to the NHS in each of the 4 nations paying higher prices than they should have done. There are 2 separate legal wrongs on which the EU law claims are based, and those are not merely, as you have heard, different packaging or characterization of essentially the same facts. You'll see this most conveniently, my lord, if you would turn up the Statement of Facts and Issues, which is at page 54. And I'd invite you to go on page 54 to paragraph 3 at the foot of the page. You'll see there paragraph 3.1 first. That is the claim based on the first head, Article 101, the article prohibiting anti-competitive agreements. The health services case is that Servier made anti-competitive agreements with suppliers of the generic version of perindopril, paying them to stay off the market. And that's what is commonly called pay for delay, and it is a notorious practice in the pharmaceutical industry. Paragraph 3.2 is the claim based on Article 102 of the treaty. And that is the article prohibiting undertakings from abusing a position of dominance which they hold in a defined economic market. The term economic market is jargon, and it roughly means a group of goods or services which is worth monopolizing. Critically, the health services claims, which are based on this article 102, are dependent on there being a distinct economic market for supplying perindopril, Servier's drug. That is the very point which was the subject of the annulment judgment. And this is so because the issues the health services are raising depend on whether it's worth monopolizing the supply of perindopril, Servier's drug, or not. You see from paragraphs 3.2.1 and 3.2.2 what those allegations of abuse consist of. 3.2.1 was a claim that Servier abused its position by obtaining, defending and enforcing an invalid patent through misleading the patent authorities and or the courts. And this is a distinct head of abuse. It's nothing to do with the pay for delay. 3.2.2 refers to the adoption of an exclusionary strategy designed to keep competitors off the market by entering into these anti-competitive agreements. And here the complaint is not the same anti-competitive agreements. There's not an identical case. It is an abuse consisting in the strategy of a systematic attempt to keep competitors out unilaterally by Servier. And the third head of abuse, which again is completely different, you see in the last part of 3.2.2, it is purchasing rights to an alternative means of manufacturing the drug developed by a different company known as Azad. The reason why these matter is because if you don't have enough competition against perindopril, from other types of drug, that is what gives Servier the market power or dominance which it can then abuse. But if you do have enough competition from other types of drug in the same wider therapeutic category, that will keep Servier honest in its selling practices, so it can't behave detrimentally to consumers. The Article 101 claims, by contrast to this, have nothing whatsoever to do with the question of defining a relevant market. Now, it's in parallel to our private law claims in the High Court that the Commission made its own public law infringement decision in 2014. The Commission found both that there were unlawful paper delay agreements, Article 101, and that it had abused a dominant position in the supply of perindopril, contrary to Article 102. And not in all of the respects that the health services are alleging in the national proceedings either. The outcome of the General Court's judgment on appeal, December 2018, is that the Commission's Article 101 findings have been largely upheld. It is the 102 findings specifically that were annulled. That was because the General Court considered, on the evidence in the file before it, that there wasn't an economic market limited to supplying the perindopril. And that was the ratio of the General Court's judgment in the view of the Court of Appeal. And if you would please, on that note, look at the Court of Appeal judgment briefly at page 189 in your electronic bundles, you'll see from paragraph 73, foot of the page, and if you would look at the last line which goes over the page, Lady Justice Rose says the reason given in the Servier judgment for annulling the 102 infringement decision was that the Commission was wrong to find that the relevant product market was limited to perindopril, because the relevant market is not so limited. Ms. Bacon has rightly pointed out that in view of the General Court's decision on the 102 infringement, we, the health services, have made clear that we do not pursue 102 as a head of claim in the damages case. It is not a part of the legal case, subject to the outcome of the Commission's further appeal on it to the Court of Justice. Nonetheless, each of the 4 findings of fact which were made by the General Court and that Servier wants to rely on as res judicata now were nothing other than steps leading to that conclusion on Article 102. They have no separate significance apart from that. To put it another way, it isn't necessary to treat those findings as binding in any other legal context to preserve the authority, the integrity of the annulment judgment, which deals with Article 102. The fact that the General Court annulment was concerned with Article 102, but the High Court case is concerned with Article 101, where the same issue of a relevant product market doesn't arise, was critical to the judgment of Lady Justice Rose. And if you would turn to paragraph 72 in her judgment at page 189 and look at the 2nd to 4th sentences beginning on line 1, she said, the purpose for which Servier is seeking to identify what's res judicata in the Servier judgment is a very different purpose from that discussed in the European Court's case law. Servier is trying to borrow 4 facts from the Servier judgment and deploy them in a context which has nothing to do with, and this is the important point, the assessment of Servier's conduct under Article 102, or with the consequences of the annulling judgment. The context is the claimant's alleged failure to mitigate losses suffered as a result of the agreement which infringes Article 101. Now, Servier in its written case did not deal with that distinction drawn by Lady Justice Rose whatsoever. Its proposed reference question in paragraph 109 ignores it. Indeed, Servier in the written case described the main point in Lady Justice Rose's judgment in different terms. If you have their written case and look at the introduction on page 71, you will see in the last sentence, paragraph 1, the top of page 71, Servier saying that the damages actions are based on, among other matters, the same infringements of competition law that were established in the Commission decision and analysed in the General Court judgments. Well, you've heard that they are now not. In the last half of paragraph 2, below that, Servier says that the health services contend that they're free to advance factual arguments inconsistent with the essential reasoning and therefore ultimate conclusion of the General Court, because those arguments are deployed in relation to causation and mitigation and not market definition and infringement. Again, not dealing with the key point. And in paragraph 3, Servier describes the nub of the Court of Appeal's decision as being that findings of fact can't be borrowed from the context of appeal against findings of infringement, compendiously, to be treated as binding in another context, but the other context isn't Article 101, it's the quantification of loss caused by the same conduct. And as you have seen, that was not the full extent of Lady Justice Rose's point. She pointed out that the issues which are before the High Court will have nothing to do with the assessment of Servier's conduct under 102, and nor with the consequences of the General Court's judgment. So with that clarification, if I may, before the short adjournment, I'll turn directly to my response to Servier's submissions. And I shall develop 5 points. The first is that contrary to Servier's main argument, findings of fact in an annulment judgment don't fall to be treated as res judicata in a different legal context in subsequent litigation. Second, that the Court of Appeal did not misunderstand the Assi-Duman case. Third, and related to the first point, the case law does not show that findings in an annulment judgment fall to be relied on in a different legal context, provided only as the control mechanism they are still within the scope of EU law. Fourth, it is not correct to say that any findings that are the necessary support for the operative part of an annulment judgment will be binding in subsequent litigation on that account alone. It's a necessary but not a sufficient condition for bindingness. And the fifth point is that Lady Justice Rose was right when she pointed out that Servier's case, as it has been advanced, has no workable limits and gives rise to a host of practical difficulties. And here I will explore the point, my lords, that Lord Reid canvassed with Miss Bacon in opening. How far does one need to go in actually interpreting these 4 propositions of fact? How far down does one need to delve to arrive at something which is sensible and which one says is the hard bedrock of the General Court's judgment? As Lady Justice Rose said, their proposition is wide-ranging and unstable with no workable limits. And this reinforces the proposition that Servier cannot be right. If I may then, I'll turn straight to the first and the main point. Contrary to Servier's case, subsidiary findings of fact in an annulment judgment don't fall to be treated as res judicata in a different legal context, in subsequent litigation, and in their own right. And if I may, I will turn up Servier's written case, which gives what it describes as the key principles derived from the authorities. You will find that on page 97 in the bundle, at paragraph 80. The critical point in Servier's case is in letter B. It says that res judicata authority, that authority, extends beyond the operative part of the reasons given by the court, to the extent that those reasons explain the meaning of the operative part, or are its essential basis or necessary support for the specific reasons for it. And the important word in that subparagraph is the first or, which I emphasized, because Servier's contention is that any factual findings in an annulment judgment, which can be said to be the necessary support for the court's conclusions, are themselves binding erga omnes, independently of the operative part of the court's annulment order. According to Servier, those factual findings will be binding in litigation involving different parties and in litigation concerned with a different issue from the annulment judgment. The only control mechanism is what is stated in the final sentence of paragraph 80D in the list on this page. The subsequent litigation must be within the scope of EU law. In our submission, Servier's position is plainly wrong, and it's instructive to compare the proposition that Servier sets out in paragraph 80B, which uses the disjunctive or, with the wording in the key authority from which the proposition has been derived, and which Miss Bacon has said earlier states accurately the key proposition that she relies on without any gloss. That is the Asteris case in 1988. It's perhaps easiest to go back in the written case of Servier to page 84, because that sets out the relevant paragraph in Asteris at the top of the page, in their paragraph 37. As Lady Justice Rose remarked in her judgment in the Court of Appeal at paragraph 60, Asteris is one of the cases about the scope of an EU institution's duty to take the necessary measures to comply with a court judgment. And you'll see that in Asteris, the Court of Justice refers to the institution's need to have regard to, I quote, the grounds which led to the judgment and constitute its essential basis, and then I emphasize, insofar as they are necessary, insofar as they are necessary to determine the exact meaning of what is stated in the operative part. The words insofar as are the only words not underlined in that sentence in Servier's written case. But by using those words, the European Court is making a point. The point is that the grounds matter because, and only because, they are a guide to the interpretation of the operative part of the judgment. The court doesn't use the disjunctive or in this paragraph, which Servier has attributed to it. The essential basis criterion and necessary to determine the exact meaning of the operative part, those are cumulative. The European Court isn't in this paragraph stating that the grounds can have binding effect in relation to legal questions which are any different from the one that has been settled in the operative part of the judgment. That was not the factual situation before the court in Asteris, and nothing in the language suggests that the court made the very wide-ranging ruling which Servier is contending for. So, my lord, with that, I see it's 1 o'clock. Would it be convenient to adjourn for an hour?
Yes, certainly, if that's a convenient point for you, Mr. Turner, we'll adjourn now and sit again at 2 o'clock.